you confirm that a person who is carrying under constitutional carry, right, a weapon, can you confirm they are not a felon? All right. My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training. Bringing to the Roadside Chat, this question comes from an officer in Ohio. Hey, Anthony, I have a question for you pursuant to the new Senate bill in Ohio 215. Now, even if you're not in Ohio, if you are in a state that has constitutional carry, which approximately 24, maybe about 24 states have it, I may be a little off, but almost 50% of the states have constitutional carry of firearm, this is for you. Right? The answer is going to be the same. The bill now allows persons who are not disqualified, like a felon, from possessing a firearm in Ohio and so forth. Now, essentially constitutional carry. With that being said, one of the requirements in Ohio is that we as the police officer now have to ask the person on the traffic stop if they are in possession of a firearm, right? They don't have to tell the police officer and so forth. My question is are we legally justified in extending the traffic stop for the sole purpose of running a criminal history check to ensure that they are not a disqualified person? Felony, protective order, and so forth. The answer is no. We don't have any case law on it, but the cases that we do have, the answer is no. You cannot extend the traffic stop for that reason. So let's go back to the logic here, right? When you stop a person for speeding, registration, etc., you can only do those things which are reasonably related to the traffic stop. In other words, you are allowed to pursue the mission of the traffic stop. If you are pursuing things, activities which are not, within the mission of the traffic stop, then you need either the person's consent and you need reasonable suspicion. So again, if you are going to extend the traffic stop for a non-related mission, like the original reason for the stop, well, then you need either consent from the person to do it, to take up their time, or you need new reasonable suspicion. This idea comes from a case called Rodriguez versus United States. So let me give you some other cases, and I'll put these links in the chat. Let me give you some other cases that kind of discuss this issue about extending a traffic stop. United States versus Stewart. 75-second extension could unlawfully prolong the stop if the purpose of the backup unit was to pursue other crimes. These are just snippets of these cases. United States versus Clark. I'm going to put these all in the link in the description. There is no de minimis exception to the Rodriguez rule. De minimis means minimal. And prior to Rodriguez, there was this idea that cops got, a short period of time to pursue other investigations. So there is no de minimis exception to the Rodriguez rule. An officer's 20-second inquiry into the defendant's criminal history is impermissible, and it extended the traffic stop. You have to have reasonable suspicion for that. United States versus Bowman. Recognize that Rodriguez prohibits even a de minimis extension, and the officer's questioning of the passenger unreasonably prolonged the traffic stop. So if you want to pursue this line of investigation, if you just want to make sure that they're not a prohibited person, well, first, look at the circumstances, right? Ask them, hey, are you a felon? Have you been convicted of it? Have you been to jail or prison? You can ask them. That's part of sometimes routine questions. You want to know who you're kind of dealing with. But look at the circumstances. Maybe you have reasonable suspicion. Maybe the way they're carrying. Maybe the way they're carrying the gun in a way that's consistent with criminal activity. High crime area. Don't rely on that alone, by the way. And that's why another reason why I don't think this is going to be permissible, because we do not want cops to stereotype people that have firearms that also may be in a high crime area, right? We don't allow that. I mean, the person driving the Mercedes S-Class that's carrying constitutionally, are you running his history? Is that what most cops are doing? Or are they pretty much taking him at face value? versus a high crime area, we don't really want to let that, that kind of potentially discrimination come in either. So, but maybe you have reasonable suspicion. But if you do not have reasonable suspicion, then the other way you can run the criminal history is A, have a backup officer do it, right? That doesn't extend the traffic stop. B, multitask. Maybe you can write, talk, at the same time and get the dispatch to run it and so forth. But generally speaking, the answer is no. If your state is going to give these, citizens the right to carry a firearm as constitutional carry, then that's the law, right? So the presumption is that they're being lawful. The presumption is not that they are a criminal because your state says you don't need a permit. All right? Maybe you disagree with the answer. Maybe you don't like it. Maybe, yes, felons could potentially be holding firearms, without and you don't know it. I get that. But this is a choice that the legislature and the governor have made. The law is, it is what it is. Personally, I support it, but the law is what it is. And we cannot just presume and have reasonable suspicion that the people are criminals by complying with the law on face value. All right? All right. If you got more questions, hey, look me up, bluetogold.com/show. You can ask me your questions. But if you like this conversation, and if you disagree, tell me why below. If you agree, tell me why below. But let's keep the conversation going. Hit like, subscribe, share with your friends. All right? And I hope I helped you get it right every time. All right, guys, I'll see you next time.